Assalamualaikum warahmatullahi wabarakatuh. Kana surangga babayan gama sabuli aisha garmar aja ay onrar muntu DBR news lera hazır yi जीवन की थेसरा दिन मारे ICJ पुरम मारे रोहिंग्या महाबला उन्हीं को इनर बाबत हाज गरियोरे तेसु बुझाई बल्ला और मुद्दा हाजर ये এখন ইয়া শুরু হইয়ে তাই ইনশাআল্লাহ আজ জয় সকল হাজার হইয়ে আমরা ভাই মেকিং মাসুলি আশা করমা তাই হাজ করি এখন দুনিয়ার হালত বেশি বেতলা ইউক্রেনের দ্বারা রাশিয়ার দরমিয়ান আমরা যে নাকি ফজাতকলর ইনর নতিজাত হার দনপতি একজন হইবারো যে নাকি রোহিঙ্গা বাবাইন আছো এইনে আমি বুঝাই দিম যে হিনরে হাজ করিয়রে খানি জানি বুঝিবা বলে আশা করম তার বেশি উত্তর 3 সেকেন্ড হইয়ে লাইভ হইয়ে তাই হাজ করি ওনারা বিগলিনে ইন্তজার করর বলতে আরি पूरा जज कर begin किया है.
Sitting is open. I would like to note that today the following judges are present with me in the Great Hall of Justice: Vice President Gevorgyan and Judges Tomka, Abraham, Yusuf, Sebatunde, Iwasawa, Nolta, and Charlesworth, and Judges Adhoc, Pillay, and Kress. While Judges Benuna, Shui, Bandari, Robinson and Salam are participating by video link. The court meets today to hear the first round of oral argument of the Gambia. I shall now give the floor to the agent of the Gambia, His Excellency Mr. Dauda Jallo. You have the floor, Your Excellency.
President, honorable judges,
it is an honor to
address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. Over 2 years ago, the Gambia filed its application with this court, exercising its right as a party to the Genocide Convention to hold Myanmar to account for its ruthless acts of genocide against the Rohingya group in Myanmar. My esteemed predecessor said that he stood before you then, as I do now, to awaken the conscience of the world and to arouse the voice of the international community. The court rose to that challenge and unanimously ordered provisional measures against Myanmar that have, to this very day, helped protect the Rohingya group from a repeat of the violent acts of genocide that Myanmar's military did not allow.
Gambia Foreign Minister Dauda Jallo hodi baturutum bayande Rohingya ko genocide gojide inal bisarara dilam
did not conduct mass murder, its coordinated use of rape and sexual violence as a weapon of genocide, its burning of villages with people locked in their homes, its targeted killing of children, and its murder of people as they fled these so-called clearance operations.
जीवन की क्लियरेंस ऑपरेशन बोली हो यारो सलाही पमार तो बोली हमारे रोहिंग्या क्लोरे जिनोसाइड मकसद लो यारो हाथ करियो सलाही तो बोली हो यारो
justice and accountability for those acts of genocide and for Myanmar's ongoing acts of genocide is not just possible, it is necessary. A solemn obligation shared by the Gambia, every state party to the Genocide Convention, and the international community as a whole. It is why the international community drafted and adopted the 1948 Genocide Convention.
Genocide Convention
the Gambia filed its application against Myanmar over 2 years ago. It is why the United Nations, the Organization for Islamic Cooperation, and the states around the world have welcomed and supported the Gambia's case. And it is why the Netherlands and Canada have publicly announced
अब दुनिया की ये आरा सपोर्ट करके कनाडा ये सपोर्ट करके नेदरलैंड सपोर्ट करके कैसे हम उधर
It is why this court must reject Myanmar's meritless preliminary objections.
Burma torbotun dinni ki objection gaji him beglen kodo torbotun reject gaji.
Madam President, honorable judges, the Gambia may be a geographically small state, but we
Gambia ho di han
international community
kanuni torika le ra has gulero pura
in promoting and protecting human rights and international accountability for atrocity crimes like genocide. We work bilaterally with other states and through multilateral institutions in our sovereign capacity for these and other
ulla gori wala ande kata halar gole gya gori botamo yen web tv maro ulla yarga Gambia case ya solve लाइव सब है इबे हम शुरू हुई हाल को जरा ये कथा है लोग करे करे ना दीवानी की बर्मा दिबा वो किला से इधर तो तुम बयान दे
However, key items of this evidence are material issued by the OIC, the United Nations,
Master OIC तुम दो OIC शुरू कर जो
Gambia or its representatives, and other OIC member states,
OIC
as well as media reports of statements.
OIC तो रोतन रिपोर्टों मीडिया रिपोर्टों जिन जी है मुताबिक आरा इंसाफ उधर दें मेरा जो OIC ले रहे
specific contents of any of this material. Indeed, the Gambia has now expressly confirmed that its decision to bring this case was taken by its cabinet only in July 2019, at which time the cabinet endorsed a proposal by the OIC.
OIC Master OIC तो नित्य
The Gambia has also not denied, and indeed has implicitly accepted, the evidence relating to the funding arrangements for this case. The Gambia says that Myanmar has glided over the evidence that matters. This evidence that matters is said to include the opening statement of the Gambia's agent at the provisional measures hearing. However, the agent was not appearing as a witness, and that opening statement cannot be treated as evidence. In any event, that opening statement gives no additional particulars of the dealings between the Gambia and the OIC and its other member states.
Master OIC शुरू हो तो OIC शुरू कर जे तारा तो रास्ता जी
describes a visit
यहाँ ना
the
लो
agent made to camps in Bangladesh in early 2018.
OIC ये बांग्लादेश में जाहिर है तारा हाल तो कल जाहिर है साहिर है.
The only other evidence that matters, identified by the Gambia, are the 25 September 2018 statement of the President of the Gambia to the General Assembly and the 11 October 2019 note verbale. The Gambia appears to argue that this evidence shows that the Gambia took actions itself.
Gambia तो वो तो स्टार्टिंग में क्या मालूम है यार मालूमात ले दी ही मुताबिक जेनोसाइड का ऐसा कथा बोले हैं अल्लाह भी साथ दिवाली बुली हो यार Gambia ये
that is not
hoyedi han luan za
in any case where a state acts on behalf of a third state as a proxy.
oda dalal buli hoya tar tar to
The
hota
proxy
so
will typically itself undertake the relevant actions in its own name and will invariably do so voluntarily. There may be any number of reasons why it agrees voluntarily to act on behalf of a third state as a proxy. But as the Gambia says, motivation is irrelevant to issues of jurisdiction. The question is therefore not whether the applicant state is voluntarily undertaking actions itself in its own name. The question is rather whether the voluntary actions that it is undertaking itself in its own name
Gambia ye reason diye de kyolla has goriore Rohingya kolor mabalare ani ICJ mare bisadudi yang sabsu tora gori hoyedi han nai yang sal hara no
is a question of fact
ara soal hin
to be decided on the evidence. In short,
bachcha mar hobe
Gambia's
digre
first ground arguments take the facts no further. The state of the evidence before the court is the same as it was before the first round. Contrary to what the Gambia suggests, it is not Myanmar's case that the Gambia is the real applicant by reason alone that it receives support from others.
arjana sabullo yoro de gojini au hin
Myanmar
hota sigo
contends that the OIC is the real
Mr.
applicant
Oizi
by virtue of all of the circumstances that have previously been set out by Myanmar. I do not repeat all the details, but essentially, the evidence shows that the proposal to bring this case was made by the OIC committee and
South
endorsed
Australia
by the
Beglin ler sabut gorode case yan OIC aine de tumhara in
After
fago
which the
de
Islamic Summit decided that the OIC committee should bring the case
itaro
on
wokilor
behalf of
digire
the
hono dio
OIC.
ogani itaro faitam nunan side
It was only afterwards that the OIC then proposed to the Gambia that the Gambia be the applicant state, and the Gambia agreed. That looks more like the Gambia providing assistance to the OIC than it looks like the OIC providing assistance to the Gambia.
Gambia ki awjal modur din tara to sab gori
I
da
move on
hazar
then to the question of law. It is common ground that the issue of proxy states has never arisen before. There are 2 points I make in reply. First, contrary to what the Gambia suggests, Article 35, paragraph 1 of the statute is not fatal to Myanmar's argument. It has no impact on Myanmar's arguments at all. This provision states that the court shall be open to the states parties to the present statute. Apart from anything else, this does not in any way qualify or create an exception to Article 34, paragraph 1, which provides that only states may be parties in cases before the court. Additionally, Article 35,
so de
paragraph 1
hono state party e bisa divide go de arhonic na wali go organization di dia ni tara tu in south de go tara hotala yo re hen go tara de odin hoidi in ro do hota sato.
Furthermore, the mere fact that a state is a party to the statute of the court, and that the court is therefore open to it pursuant to Article 35, paragraph 1, does not mean that the court will have jurisdiction over any case brought by that state.
Arizona Dalago Ayere Keski Jedihan Mare Kurotun Hedur Ejazuna de Arizona Kalaf case.
The arguments previously presented
Agility or Ara Hotahan, Hoitihan or Ara Sabugola Kushikuri.
apply equally to Article 35, paragraph 1, and the latter provision takes matters no further. The academic texts relied on by the Gambia in this respect were not addressing the issue now before the court and are not inconsistent with Myanmar's arguments. Secondly, the Gambia conflates two separate issues, namely the motivation of a state for bringing proceedings and the question of whether the applicant state is in fact bringing proceedings on behalf of another state or entity. The Gambia argues that if the applicant brings proceedings because another state or entity wants it to, that is simply the applicant's is irrelevant to jurisdiction. This is incorrect.
Jurisdiction
indicating how the use of proxy states according to principles of reciprocity, good faith, and effectiveness. The bringing of a case as proxy for a third party engages principles and issues going well beyond the principle that motivation is irrelevant to jurisdiction. This distinction is far from artificial. Madam President, members of the court, I move on to the fourth preliminary objection. As to the legal principles, Myanmar has not abandoned anything stated in the written preliminary objections. I note that some of the definitions of dispute found in the case law may in fact be worded somewhat too broadly to reflect the actual principles applicable to determine if there is a dispute. Myanmar contends that the correct principles are those set out in
Burma Odode Rastamare Soy Ase Burma Harkamare Soy Burma Yagangari no Soy Yanular Kuroton Kogaraurigo
is reflected in the Marshall Islands cases. I have also already explained why, contrary to what is claimed by the Gambia, this requirement would not give the respondent a silent veto over the bringing of cases before this court. Contrary to what the Gambia suggests, I did not say that the parties must enter into negotiations before a case is brought before the court.
Arita Hodiki, I in the case, Kuroma, Anibaragusun, the Deshala Delita Lera, Hotawatara Banga to Yano.
Two parties
Into Dua Party, the Garden Dalal, Dalal,
negotiations between them taking place, or having yet taken place. And indeed, this will be a common situation. I did not say that the parties must attempt before going. Rather, I said that because the court is an alternative to the direct and friendly settlement of disputes, there will not be a
Gambia, Patamania, Gambia, Patamuta, Beck,
unless there is a dispute that could be the subject of friendly settlement. And for this, both parties would need to be aware of the other's views. Contrary to what the Gambia suggests, I did not say that an applicant must articulate its claims in such detail that it would effectively have to share a draft of the application with the potential respondent. Rather, I made clear that only a minimum degree of particularity is required. Contrary to what the Gambia apparently seems to suggest, the court's case law does not indicate that there is any defined time after which silence by a respondent can be
Bormatu job no the diyan ke silent atiyara istemal gojje job no de niramai de ke inkaro no gore ngore tara deba time no ek maborno gore hor yano saavuttu
on the individual facts of a particular case. If it is, the maximum reasonable length of time for a response will also vary.
Amaskom kesu time pojjonto bormai job jodi han intezar kora utto intezar no koriyo re bodor kori case kudo mar diye gai kintu Gambia hoda ar 30 din hoda time ni amba bi or saiti kafi hoyi.
I said that the note verbal did not call for a response at all, but that even if it did, a reasonable time for a response would have been more than a month. For the reasons given in the written and oral arguments, matters relied on by the Gambia as establishing the existence of a dispute, apart from the 11 October 29 note verbal, could not possibly establish the existence of a dispute.
Kanuni torigal tara tamara gojji ba kanuni torigal no
It is indeed
yanalla arankar goridde
that the note verbal did not state any facts.
oh Mr. YC tara namu to jeto Mr. YC
FFM report and to
itara din gojji fat animation or sai report bar sai movie kaise de
that there is no suggestion that the Gambia had access to the fact-finding mission's primary evidence on which the report was based, such as the witness interviews that it took.
report din lai hin to SHARE report fact finding mission to hotun din aje Rohingya kolor real din ki zulum ye inar baote duniya re dai ar hin or report kol has goriore duniya re dai dena ar hin no genocide intent buli hoyore fact finding mission or ugada marzo ki dar sun hoida ase inor tara gurai bolla kanuni dao peshin kala bolla kushi korto endi logo gotiya hodome bolla ari
Does not mean that the note verbal
mara biya bai wash hand kala hor jabra lombai
if it otherwise would not. Indeed, once the Gambia announced publicly on 26 September 2019 that it intended to bring a case before this court, the failure of the note verbal to mention this intention gave rise to
tara diyanne ki kaisa ni an chaos kyalla ni di han or sundo gori explanation dono mare kejiya na kamiyab oi video hoy has gori hoye di an or
since
saha
after 26 September 2019, there would have been an even stronger expectation that the note verbal would refer to this intention if it was indeed a legal claim. Madam President, members of the court, that concludes my arguments on the first and fourth preliminary objections. I would now invite you, Madam President, to call on Professor Talman to address the second preliminary objection.
दूसरा नंबर preliminary objection din asin diba दूसरा नंबर वकील asi tare daud diwalla ugara re job da has goji ida ode OIC layer din odin hoyi no dar bar repeat kar de tar to ar kono hota nai na dilam naya mario naya police ko nile de puram bolaba na naya bol nile de
Madam President, Mr. Vice President, distinguished members of the Court. My task today is to respond to the Gambia's observations made in reply to Myanmar's
Burma fatare job dedi hi namar mar khata hon dia
the
mote
Gambia lacks standing in this case.
Hesian man muzbut guriti anamare homyo tasdin da hain dia
You
mote
heard that Myanmar's argument was absurd,
Bur
abject, ahistorical, erroneous, tenuous, concocted, and unfortunate. What you did not hear was any positive argument that the Gambia does have standing in the present proceedings.
Ehon ma wala asdi namar e Gambia ye jinne ki job diye ni thono rasta mariyo nai so yo no
Oral presentation, as in its written observations, constantly and consistently conflates, or better mixes up, the
dolla mani ni alaya taratorutun dilla khesare confuse
in
gorde
proceedings before this court. Of standing to invoke the responsibility of the perpetrator of genocide.
ar Gambia ye hoye de genocide or dinne ki zimmadari ase inara aday kori dibule ni ana kai job
Of
de
responsibility and standing are two distinct concepts.
itara dian mo khale yore tara ke ide sesian
Expressly noted this in its commentary on the articles on state responsibility, which I quoted on Monday. Myanmar addresses the question of the invocation of responsibility only because the Gambia erroneously equates a right to invoke the responsibility of a state with standing before this court, and draws the conclusion that whenever there is a right to invoke the responsibility of a state,
zimmadari dian asi anara aday kori bola kuroma bisati bolla Gambia tu ne jado ta se mo ide kaunni right sahiye modde anare
is not the case.
yan khesodano
But let me address the Gambia's argument with regard to the invocation of responsibility.
zimmadari de job de diha amar taratorutun hoye di ana ai job de
Contrary to the Gambia's assertion, Myanmar has not accepted that the
Gambia
Gambia
zian hoye hi anara borme to ono la kenno gore
in the present case.
ehono time maria chujon
No such admission was made, and no such conclusion can be drawn from the court's finding in its provisional measures order that Myanmar accepts that the Gambia has an interest in Myanmar's
a provisional measure didi hi no yo has gori borma yen la ken go jedio nai
Second, and more importantly, the Gambia cannot invoke Myanmar's responsibility with regard to alleged acts of genocide committed against non-nationals outside its own territory.
nizar desham mare bidishita odon dini ki borma deshita no hita rakhala fendra zulum golle desham manjore na golle genocide Rohingya hodi inde genocide no in deshita ko no hita zulum golle ando genocide ido no ya rakhala ken ke diverigo ya amma ke allah di magale go de borma deshe
The responsibility of a state may not be invoked if the claim is not brought in accordance with any applicable rule relating to the nationality of claims. End of quote. The text is clear and unequivocal, and so is the ILC's commentary. There is no exception to the nationality of claims rule for certain treaties or certain types of obligations.
sarhatol je jibari ke ayelo ase iba mutabe khonogwa deshitar ma wala do dino to digi le onyo deshita oduno endra claim kori bolla endra bodendra kori borobbo in or kesore ICJ mane dibar rasta na
That the rule of nationality of claims is a general condition for the invocation of responsibility in cases where it is applicable. Let me first highlight that the ILC itself calls the nationality of claims rule a general condition for the invocation of responsibility. So the nationality of claims requirement is the rule, not an exception.
Hitararu zulumwajidi hin autu deshita to auru deshita olena desha manjurga tu zulumgo job deshita ge hawa go na varos yanor sayora na kede vergo andila deshita to no yore bormala hon tal konna jendila maawala kadani yore borma re kede na
applicable in all cases in which a state invokes the responsibility of another
state
of that state, but for injuries allegedly caused to individuals in Myanmar's northern Rakhine state. So, what arguments has the Gambia put before you for its contention that in the case of the Genocide Convention,
Argentina kenguru available the deshitaro dunungolena genocide in the rasai the deshita no kanuni the tara deshita no tihanu mara darakara case kenguru
nothing in the convention suggests that it would be. End of quote. But one must ask, must there be an indication or even express provision in the convention on the application of the nationality of claims rule? The short answer is no.
No,
the Genocide Convention deals with primary obligations.
Aso gujali genocide convention hon tarara go hodo digile dini ki deshita ase khazbi ya deshita da no yoro ya odihano genocide convention ki madane
general conditions under international law for a state to be considered responsible. These secondary rules apply to all treaties. So there is no need to deal with these general conditions in each and every treaty. Example of a treaty that indicates or expressly provides for such application. The reason is simple. There is none. The application of the nationality of claims rule does not depend on the treaty, but on whether injuries have been caused to individuals. And I quote again, would be contrary to the object and purpose of the convention. End of quote. However,
nationality
why the application of a general secondary rule would be contrary to the convention's object and purpose. First of all, the Gambia does not clarify the object and purpose of the convention, but simply states that genocide is contrary to the spirit and purpose of the United Nations, and that it shocks the conscience of mankind.
इंसान हिसाबे गजरे किंतु कानूनी रास्ता ले उसी गजरे हम कंफर्म करियो ना हर genocide
of the convention, and why a general secondary rule of international law should not be applicable in the present case.
It
is submitted that the object and purpose of the convention is, to quote the court's own words, to condemn and punish genocide as a crime under international law. By establishing individual
genocide of कैसोरे हाल के रेले दुनिया का मुताबिक अंदर जॉब दिवर रास्ता से सारा दिवर रास्ता से किंतु genocide is of देशिता अपलोड जुलूम में genocide
must be seen against the background of the Nuremberg and Tokyo war crimes trials, and not against any interstate claims before this court. As the tribunal at Nuremberg held, crimes against international law are committed by men, not abstract entities.
Ya to international crime diniki azizima hitara endila gurun gojendilo idobo
historical.
kintu endila no
The
to
object and purpose of the convention does not demand that any contracting state can invoke the responsibility of every other contracting state with regard to alleged acts of genocide committed against non-nationals outside its territory.
Baror ginore dulung gojeng modo digile nyan genocide case no bone kintu insanoro dulung gojendilo pheri gode nizor deshitare na dulung gojle deshotun sagur hotongori ola khushi gojle tararore na dulung hinore genocide pawa jabo outside আর বুদুন বিদেশিটা বুদুন বাড়িকার মানুষ বুদুন জুলুম গলি ওই আনন্দে জুলুম হয়ে বেরিয়ে দুনিয়া কানুন মোতাবেক ওয়ার ক্রাইম দিলে হয়ে বেরিয়ে জিনোসাইড ফেভার রাস্তা আমরা জিনোসাইডের কেস কথা এটা নিদি হ্যাঁ জিনোসাইড নো দিন দিলাও তো মা বলারে আনন্দ বলছি
The application of the nationality of claims rule to the invocation of responsibility in case of injury to individuals may, in the words of the Gambia, lead to unfortunate results. But the Gambia has not presented any convincing argument why it should not be applicable in the present case. The nationality of claims rule precludes the Gambia from invoking Myanmar's responsibility with regard to alleged acts of genocide committed against persons who are not its nationals. Thus,
তারা দেশির তারও গজ্জিত ওইনে নয় তারা সাগুলের দাহাই নদী
any bearing on the question of standing, which it has not,
আর হাল্লাতি এই দিয়ে আমরা দাহাই নদী
could not
আল্লাহ হইলে সারা দিন নাম হর রোহিঙ্গা আনি রোহিঙ্গা ওদিন বর্মা দেশিরটা ন হিন্দিলা হদ বই তার
Madam President, members of the Court, the Gambia asserts that in case of the Genocide Convention, standing does not require an individual legal interest, but that a common interest in compliance with the Convention is sufficient. It is correct that the Court held in its Provisional Measures Order that all states parties to the Genocide Convention had such an interest, and on that basis found that the Gambia has prima facie standing to submit to it the dispute with Myanmar. The court reached this decision on the basis
Gambia এখন তারার স্ট্যান্ডিংলে সাথে দিয়ে গেলে Gambia হসুর বন্ধ নিয়ে যাবো ওই আফগানের ধরে দুনিয়া গুলো লাগতে আমরা
both on grounds of fact and law.
ও বাদে বুস্টার ভ্যাকসিন কি নম্বর কো মারি বেশি
The
দেন
court's own statement in paragraph 85 of the Provisional Measures Order that, I quote, "The decision given in the present proceedings in no way prejudges any questions relating to the admissibility of the application."
application yani kesianore gibar soi rasta sagburiore dahai di numare Gambia na kami yang
those questions. End of quote. As the Gambia has noted, new argument has been submitted at this hearing on the admissibility of claims, which in Myanmar's view shows that the Gambia lacks standing in the present case.
এখন kesianon mare Gambia soi gorke harde dahan
This will
hogar
not be the first case where the court decided at the provisional stage on a prima facie basis that it had jurisdiction or a claim was admissible, only to hold later that it was without jurisdiction or the claim was inadmissible. It is thus far-fetched to assert that by welcoming the Provisional Measures Order, the United Nations General Assembly and the member states confirmed that they do consider the Gambia's standing to be established.
Gambia dini ki mawala banai ba cara alag guru banai itu dah in General Assembly tu dah guru confirm goji.
The Gambia tries to dismiss Myanmar's argument based on paragraph 91 of the court's judgment in Barcelona Traction, because the paragraph does not expressly mention the Genocide Convention.
Ar Barcelona mawala mar dini ki ase sana donor ko torika loi ni mare he anu to hanoka genocide mention no kore.
Of violations of obligations erga omnes. Taking such obligations under universal human rights instruments only as an example. The court held that the erga omnes partes character of these obligations have been established to protect a common interest.
Gambia tu betul common interest lor has been revealed. Dia imika saya dunia kanun orang hebat tu limbuli orang hari ini inter no tara niga fayda tu libola niga biagur bola nggak betul kita Gambia job dia arah kata des arah tu armiga kes anjir saudara salah orang arah des arah tu saudari asa arah ke des hukumat arah tu mutas no niga bade arah des rule of law ase nggak job dia.
Why the nationality of claims rule is applicable to
nationality case jina sini kala kurang mare lakin ngori harde kala holi insani hak isabe India dile farade kintu kanuni to kala ri barato korina ware kala gainala case di hitara formar deshita no.
In the Barcelona Traction case, the court contrasted the situation under universal human rights instruments with the situation under the European Convention on Human Rights, another treaty established to protect the common interest of all states parties. The European Convention, in its Article 33, expressly vests a right in all contracting states to refer any alleged breach of the convention.
European Union or convention mutabak konoga party ya to deshar agent hisabe hamgor to digide hum dilago kori odi to ko da haji hi baliyo no sai kara.
The mere fact that a treaty is established to protect the common interest does not suffice to establish the standing of all contracting states in any given case.
Utara loire hasguri contract ko jakada desh hang loire hasguri utara barba kodo. In begin pura gare anor mani ji o aisilo dulito case kharaj go. Nan to noi go. Nene fisare de ila to nai kudor jojo klor de bezi pe boto.
About the legal interest or standing of the applicant. For the Gambia, this passage is irrelevant because the court did not decide these questions. But this misses the point. The fact that the court felt it necessary to raise the question shows that the parties of the Genocide Convention
Genocide Convention or misuse করে বলা ইস্তেমাল করে আর হিতারা মজবুতি করে কি এসে পন্তরিকালে আছে ইনরে তারা দাহন মানা কান.
Members of the court, let me now turn to the Gambia's novel definition of standing.
আর কি হিতারা কি আল্লাহ কে জানা নিদি না আর তারা তো মানি হই দি আনরা আই
right or interest regarding the subject matter of a party's claim. The Gambia now offers you a new definition. Standing now supposedly requires that the interest in respecting the rules at the heart of the dispute. End of quote.
Tara khao dana fu
This
edok
new
kujon de ka sama asali.
definition calls for several observations. First, this is a purely results-driven definition. A new definition has been constructed only to prove that the requirements of the new definition are met in the present case. Second,
Tara na yamani
the
ala
case
ye
of
kes
SS
elamar
Wimbledon is a bad starting point for any new general definition of standing.
na yamani ala ide tara ye kes anama kela shidi hi inda re kada bid bisho kharab da hazar.
386, paragraph 1 of the Versailles Peace Treaty, which provided that in the event of violation of certain provisions of the treaty, any interested party could bring the case before the Permanent Court of International Justice. Article 386, like Article 33 of the European Convention on Human Rights, thus provided an exceptional authorization of standing.
European Convention मुताबिक फोन तरीका लेरा हम गरा बुरीन और बाबू के साथ करी दहाइये और European definition तो तुम्हीं क्या लाना और इन तो आना बोलतो यूनो Convention ले जाता ना यूनो खानून ले जाता ना यूनो शारा मत इना से दिवाले ये तो आरा दहाइये ई बात ले जाना इके उके दहाइये तो आरा टियाँ हो तो मरना तो रोमो तो Bosnian genocide मामला गया था मामला इन क्या लाना हो रहा है जरूरत तो नहीं.
Madam President, members of the court, let me conclude again with a general observation. Listening to the Gambia's conclusions on Wednesday and its assertion that it has standing to bring this case against Myanmar because any other finding would seriously undermine the value of the convention.
Tara to kaisa ni din arjun to ayra faide hendila report hi noro loyo ayore insano ki motire mundo ani o gojjo hodde am
Christian Morgenstern. For he reasoned pointedly that which must not, cannot be. But this is not the reasoning you are supposed to apply in this court.
Kesian kurang mare apply jadi yang mani yang harus job no.
In accordance with the established law on the admissibility of claims, that the Gambia lacks standing in the present case, and that accordingly its application will be dismissed as inadmissible. I thank the court for its kind attention. Madam President, may I now ask you to call on Professor Kolb to present Myanmar's third preliminary objection.
Third number preliminary objection the volunteer of cause diva wakila se itare daud diyan da habar. Dalba tu gadiyari sinaniya. Don kutan. Ida tu diyan Kes salaibar ijazat nai tara han le tagi goi kala tara zulum gojido oi hi noro sabut gori bari bodi Allah diara ge dibo ukila shilba to bairi giye goi kintu এখন দুধে তারা তো দুধে উবা আর্গুমেন্ট করো দেখি আল্লাহ হইলে তারা তো আর রাস্তা নাই উকিল হি নিও জানে দে কানুনি ব্যবস্থা হন দিলা দিয়া
Madam President, members of the court, I'd like to return to my arguments on the third preliminary objection.
Third number preliminary objection is our motto
I have listened carefully to my opponents, but I must confess entirely satisfied with their interpretation of Article 8.
Article 8 is lawyer with explanation Germany number task na ko jadi hi number muka we are not satisfied no razino
Question through the lens of Article 8.
Article 8 mutabak sabdo digile
Then I will examine this again
I am the
procedure of the reservation, the two lenses are not identical. And therefore, what is observed is different depending on the reference point that is chosen. If Article 8 does not concern the seizing of the United Nations organs, what can possibly be the meaning of Myanmar's reservation?
Article 8 मुताबिक दिवम आरा होइलम ही हमारे तारा तो बुतन जवाब दे गलत जवाब को ले ही नंबर परमार के इंग्लिश तुम्हारा के समा का ये रे मिला तुम गोरी होगा
that has no effect from
our
point of view.
Our point of view में साधु जी की ले देने के स्टेट पार्टी आसे गैम्बिया इधर समता तो सही तो नो.
If a state takes such care to enter a reservation to provision in such an important treaty, it certainly aims to achieve legal effect.
कानूनी पावर पर गैम्बिया है वाला बोले बस एक गुजरी अंडा हाथ.
Gratuitous, senseless,
मानो कदा मानी सारा dan aksara.
I simply cannot resign myself to accept.
Ani jadi di yang ada tu kau guna hari itu ke Allah
Let
aja.
us assume that Article 8 concerns only the political organs of the World Organization.
Article 8 हमारा हाथ में जिंदगी तारा दहाई की ये ही वंगता है कौन ले जिंदगी particular organization क्या आलोक करा party state party गोरी हारती किंतु head organization आते हैं यहाँ माइन निज बुझना वाले थे कि अल्लाह को लोग कबूल करते कैसे हैं
depending on the relevant provisions of the Charter, such as Articles 35 and 39. It would be unreasonable to claim that the reservation to Article 8 of the 1948 Convention could impact the jurisdiction of these organs under the Charter. If so, it would still be possible to argue that their season for
Accusation the time as the Taratun Burma Kasian or Gorilla Taranoli Botunika Bezidio Tara Diniki case of Kolgi, Tara Dinika argument of Kolgi in Ara Huidi or Job Nova.
Could concern genocide as a threat to
Tara Hobby genocide or Sindagori or genocide are not novel and the Hobby him, Duna Banauti.
the reservation would not apply.
Emma him that the Burma
It
no.
had no useful effect
Allah will
in the field of political bodies. Even more so if Article 8 doesn't concern season. In this case,
Article 8 yang das has the कानून नंबर स्टोरी है यूनो ही मुताबिक हनों कानूनी तरीका ले रे गैम्बिया ही सब ऊपर नंबर ना खाएंगे
Article 8 also concerns the court. If it does not regulate the season of the court, but leaves that to Article 9, once again, Myanmar's reservation to Article 8 has no effect whatsoever. The court would be seized on the basis of Article 9 and have
पूरा तो रोज तो हाथ की जॉब दे रहा Article 9 मुताबिक जिन्हें कि गैम्बिया से तरह बंगा क्लब भी सद दिए तो बोले कोई नहीं है हमले
Let us assume that Article 8 does not cover the seizing of the organs referred to, but merely recalls that they may be seized on the basis of other texts. Then why make a reservation to such a provision?
अखंड के तरह ही वाले यार सब को रियल नो आइडिया अल्लाह बोली यार प्रोविजन इन कला दिया बिजे कानून इन अल्लाह बोली दे इंसान रो हवा तो लानो नहीं इंसान रो बेच दी करी वाला ने
I would like to recall that the intent and purpose of the reserving state is crucial to the interpretation of reservations.
अरे इंदिला कोरो टाइम बर्बाद दोन मारे हाथ को जो ने इंदिला माँ बोला इन आनंद ना करा कोरो तो टाइम बर्बाद दिवान
Concerns only the season of
Article 8 दिवस ही इन्होंने कदर करा उड़ी वो कानूनी तरीका ले जाता उड़ी वो
cannot be prevented by entering a reservation.
आरही भैया हम कदा क्या रे
This reservation
सबूत
does
नगरे
not
फाने इंदिला
extend
Article 8
to
दिवस ही बाप
the charter.
यूनो शाड़ा तो ला बोला ये फाने इंदिलो
The
इकी
reservation would have no effect. third hypothesis, that Article 8 concerns the seizing of both political and judicial organs. However, the seizing of the court is regulated solely by Article 9. For the umpteenth time, the reservation to Article 8 would be pointless, have no effect, and no reality, because the political bodies can be seized. The court can be seized on the basis of Article 9. Therefore, I dare present a fourth hypothesis, that Article 8 concerns the seizing of the court. The reservation now rises from the ashes, and its effect of not allowing the seizing of the court. This is the only way in which the reservation can have a useful effect. It is the only way to respect the will of the reserving state.
Are the additional bizarre and risotto Bavio, Hanaka Ham Goravito, Rokian Hanga Goronan
Let us
Zuri?
now rest in perspective and place ourselves in Burma's optical field. It is this shift in relativity
Our county Silent Marahas Guriore, Gambia, Burma, Tanya, Gola Pushiko.
if the state had doubts,
In the article, Vivasi of Burma sign over.
reservation could prevent the seizing of the court,
Our code or Divanica article, Ashtazi, Bamutavi, Burma, County Bay, have other good.
Article 9.
Article 9 layer into Bisatio, Hoyo, Tarayan, clear Gurier, Saburikinava.
However, if Burma indeed considered that its reservation to Article 8 would prevent the seizing of all UN organs, it becomes easy to understand why it didn't enter a reservation to Article 9. Otherwise, it is not understandable. In more or less discreetly, why didn't you do so? With a slight hint of reproach.
Tura already put the Hinore, Mata, Loyer, Batu, Gujalton, Ilaka, Butani, or has good Purama Visatini, that's it. Kangaroo, Bishaguri,
No longer necessary. Burma believed that it had already ruled out any seizing of a UN organ that might interfere in its internal affairs.
Arbutor Mara has good year, Burma was it there, our Bardishutun has good year, he got a tangle like this. The Labutor Mala, Nara, the year of Hari, or Godivala, Power, saying, or Godito, Ara, or Godiva, say, with Jam, where have good wind. In the Burma Martha, Honka, the night or Rohingya, Rumor, Akamali, the Gakamari, Jaman, the Nagishina, you give Zamaire J. And the Bosnia case on Mara, the ICJ Budoton, Shinare, and the Lakamanivola credit card, the Amanilla, Yay, Rohingya, Akamali, they ran the other
So as to make
Alagorio, Rakula, Pushigo.
If this is done, then the objective interpretation of the relationship between Articles 8 and 9 of the Genocide Convention is not decisive. Even if our opponents were right and Article 8 were objectively irrelevant to the court, the fact remains that one must pay attention to Burma's representations in order to understand the meaning of its reservation. It is important to look at
argument
if we do so,
Article
8 related to seizing, its reservation would have had no useful meaning. Let me switch perspectives again. We have the case here of a state entering a reservation that it deems absolutely necessary to a provision that it considers important in a major treaty.
कानूनी व्यवस्था ले कानूनी मुताबिक देशों को तो रोमांचर इंदिला करो तो जो गिले या कानूनी प्रोफेशनल मेजर हम का दिया बोले कि जो इधर तो कानूनी मानुष्य न आर देशों को तो मानुष्य न बात देगा और मानुष्य इनों का लाभ इंदिला एक्शन ले यदि और हमारे आम को देशों मानुष्य जो सिविल का वायु रे इंदिला का एक्शन लो ना कानून और बैंगे होने दर बोल.
And now our opponents are asking this court to ignore such a reservation. They are asking it to act as if it didn't exist. What message would the court send out to states that are following its jurisprudence so carefully that the court doesn't take their reservation seriously? That it allows itself to नाकी कुडोत्तर बत्तों कानूनी व्यवस्था करी बोला दुनिया रे डरा बोलते नाकी अन्य देशर स्टेट रे डरा बोलते सोई माँ वाला के अल्लाह उदू करी और तो नहीं है यहाँ बर्मात तो बत्तों सॉल्व करा था. However, it is not our task to ignore them.
आरा यहाँ मानी नॉन दे आरा मस्त यहाँ नॉन दे कुडोरो इंकार करोन किंतु कैसे पता ना होती हैं कुडों में नहीं दिया आरा इंकार करते. To a paradox in our opponent's reasoning. If Article 8 indeed concerns the cessation of political organs, and the reservation does have effect in this respect, it would mean that cessation of political organs would be barred, but not the cessation of the court, which would be preserved by Article 9. The consequence of this would be that Myanmar would be protected from the season of organs that only issue recommendations most of the time, but it would not be protected against the season of the whose decisions are binding on it. That would be a strange effect for a state trying to shield itself from outside interference. बार्डेकर मानुषुन वाले देशर पुत्र आनी और बहादुरी वाला जी बोला आर देशर तेरा बदनामी करी बोला इंदिला वो हम कर दी डबल स्टैंडर्ड इंडिया करा वो यहाँ हाथ करी और कदा पावर वाला देशर है हाथ करी रिस्पेक्ट करो ना जरूरी केंद्रीय यहाँ करो ना मानना चाहिए. Allah आर्टिकल और मानी दिवा आष्टवासे इबारत दो साथ दे गिले इतार देनी के सब थोड़ा आर अभिमान को जिंदगी ही ले यारे कैसी अंदाज़ से कुड़मरा आनंद जोर रोतो दानो.
I have just expressed our main problem, the main problem that I run up against.
नॉर्मल मुश्किलों तो दे.
Stroke of a pen, remove all legal effort or effect from the reservation expressed by Burma and turn it into a legal zombie, even more.
आर जिन्हें की कानूनी रास्ता कलासी इंसान केंद्रीय लोहे माने किए बोल जिन्हें की बर्मा तो बोलतों बयान को देरी इंकार करे रीन और ऐसा को जरूर रिमूव करी करे दें दिला का रास्ता बनी किए जो
would have some difficulty in concluding so. Nothingness is a concept which is interesting in philosophy. I don't believe that it is so as regards the world of reservations against treaties. We cannot adopt a solution which would be tantamount to completely
kada sabko yore mani ne ala inna faide dinni ki Burma ka last skuli bare jabo asudo hoddi han ana hana kanun to na bare hana facts to na bare hana rasta ye no diki yana mare kudiyo kya no buze kudiyo kya kanun no mane.
I'll now turn to three arguments advanced by our opponents. Time is too short to run through them all. I don't think it useful to keep you spellbound with detailed explanations, tedious in their technicity, and useless as regards the information already assembled in our pleadings. The first argument, the distinction between injured states and non-injured states does not allegedly fit with the texts. Our opponents have stressed that Opponent 8 would not support it.
Bormala buliara diniki mamala bujingi ingembela hono samoyi je tara goriwara hodi han kanuni no.
And I agree.
Kintu dimagara lagera hodi han holi ai kintu kogori kintu itara hamaka reasonable fact dinaware.
Does this text of the reservation allow for such a distinction? To surprise you perhaps, my answer would be no. The reservation excludes every application of Article 8 from the scope of acceptance of Burma. It draws no distinction between
organization ayero Burma khilaf bisar jihari ko rasta indira kor jehone debe.
But where does this distinction come from?
Kintu Burma hoje ankara power la desh ankara indira be kanune hamkor poribar rasta nahi.
Myanmar would be entitled to count on the exclusion of all seasons by basing itself on the implacable text of its reservation. But it didn't want to go that far. It preferred to limit the extent of its reservation.
Kanuni sayi UN kanun begin saddo jigile itara udon shesh dunya laira honla confuse goribala khushi korote kintu mawala into dunya e dekhe nyan aro hono dakhala nagoribo kala Burma din ko je zulum yo kor ino to job develop Burma ko nai.
Opponents would prefer to stick just to the text of this reservation. Then the legal answer within the viewpoint of Burmese intention is simple and straightforward. Every season, whatever, is excluded whether it comes from an
har kada halat mare Burma hodi an case yan to bare Burma la case corona zurur no yan la Burma din ki view of point asi wala ye re puro solution ke su bujiyo so
as to solve the current case.
ar ma wala yan Burma buto gorobala hal do yore ya ge da hal buji ya ase lagatar goribo
To exclude season ending up in interference in internal affairs.
Buturga ma wala mara khas ko yore onyo desha kara tun goliyor thangala jonna zururot na yan desha butor kanun vyavastha dinasi inore soga ko johanu.
If the reservation only covered articles linked to Article 2, Paragraph 7 of the Charter,
should the article even if you number ase yan to puru go hoila monramuntu iba mutabe
radically exclude the application of Article 8 and not simply limit oneself to reproducing the usual contemporary language about internal affairs. The second argument. Great play has been made of the travaux préparatoires in Articles 8 and 9. Here, this is a series of tortuous facts in a list of positions, sometimes changing, whose interpretation is not so straightforward. It's also material for an oral presentation highlighting the most salient facts. I'll allow myself, therefore, to refer you in this respect to our written pleadings. My aim was to draw your attention to the fact that summed up in the words, organs of the United States, the United Nations. There is another reason why I didn't insist on the travaux préparatoires. The Genocide Convention is a multilateral treaty.
Genocide Convention is a national treaty international law
and on other objective elements.
Arhad Donahi Naman Gabin deliver object deliver
Whose task
Udavagare.
is to confirm or to clarify a result
Ahi
of
nor confirm karabu jin maamala to jehi nor confirm karabu clarify karabu ba ahi nor mare kiki ase na inda pakka sabu le ka hauri go inda bayar rotu doriyo riba kada maamala karo ando honotada reason nahi.
that the court is a competent organ of the United Nations.
Ar court for the anakada kodor yuan kada door organ yani ki hissa.
Jurisprudence has focused on this ancillary role of the travaux. If the so-called objective methods
Arendila maamala karo dihi honotada mani sarai nor ras go jere inda doriba beglen mani aiye.
one cannot choose deliberately or arbitrarily to apply them only to civilizing provisions whilst leaving them aside for provisions which are more technical in nature. A convention is not a potpourri in which each reader can behave as they will. There is a reason, furthermore, for not to have placed a great deal of stress on the travaux préparatoires. They are secondary.
More point of view lo sado digri itara od do odino ginor fakra thai dani ra han ga thamim barbat de din lo ko itara tun thiagin hodo mole Burma diba ase ke hotel namu kala guru koi thike itara do unor sawate ke badar din namala.
I will briefly evoke the travaux so that you don't think that I wish to avoid them because they would not provide enough grist to my mill. I would raise particularly two significant facts. Articles 8 and 9 were negotiated together.
Article 9
Merged during one phase of negotiations before again being
Auto tara hatavatara hoy mashara goriyore inere honakara dorina baraban auto lo sarate kinen dilla goriyore banayore
the
rakhe.
gateway, if you will, whereas Article 9 detailed the specific nature of aspects of jurisdiction here at the court. You will not see this watertight
Article 9 Kesiana Mar Dahana
of domains
Kala article 9 is the Deshi Dihar Denga, all the K. Wazira Mardri, who is Saditi Mr. Wazi, only Mountain with that with you.
At a very advanced stage of negotiations,
Inshallah,
the
Muslim
Treaty of Article 10
Oyu Hono Ara Honomikatu Fida
used the
Taguno.
words any competent
Niba
organ
Pada
of the
Burma
United
Putitara
Nations.
Diniki Komasita Rago Convention binding over the
Except
Kinto Rohingya hak lo dio the Rohingya komutu monto auru.
our opponents have analysed the
Zeto
meaning
gya o
of
goi
Sizia
zarhana tato ha ora gana habe hono din nodi. Ehon
by stressing
yogirina
their
ma bola so
inclusive nature.
bigirine hoila larai no je odigi ara dor ko ate asi dor ate ar diu mino ya mote yuruba de diplomacy tarikala era has de tianda hana mina mo ko mo den dor larai ro.
To the judicial
Am
organs
motte
and
ki
the
yogirina odigi ar
of the
motta
United
ara
Nations.
bigilin de ara ai bobile hoye
According to which
यार तुम्हाला आम्ही हो निके साथ दिन बरबाद बना काले बोया दे आर सेंशन को मार दे जा पर वादा दे दे करो दे वो देश तो कल तुम्हारा निजर देश ने तो बात तुम ना दो दिगले होती रास्ता मारा जो गए रास्ता ताई रा हाउ कर होती तो ना दे दे साथ दे दिगले देश बात बोला आर होती तो ना दे दिन बोले है रा हाउ कर का को यो इंग्लिश तो तो यो कर ना हो दे दासी इन तरह से नगरना और इतर यो दे रोंगर मारी वाला बोली और परमान मिलिट्री आके बिची
Travaux préparatoires concludes some sparse elements supporting this inclusive meaning. If you look at the position taken by Sir Hartley Shawcross on behalf of the United Kingdom, he included in the organs covered by Article 8 the International Criminal Court, as yet uncreated, to punish the crime of genocide.
Cara बहुत खुशी गरी सही ये दिन साइज दी कानून हमारे दे दून बुरे भारी इनर ठानी है पुरानी भाई की वैसा है ठीक है तो खाना 3 घंटा टाइम भाई आज जा 3 घंटा भाई वो दिन 3 घंटा भाई इन पर वाला ये वॉइस हो आज जाके सो वाली इनर के सिल्वर नहीं अंगोरे टाइम पूरा दे दे रे.
One comment has been quoted against me.
It refers to Article 9 of the Convention, and therefore covers the jurisdiction of the court on the basis of the compromissory clause.
Jurisdiction in kanuni action le variable hai dene ke ho riba de paitamara ho dile pura kanure taimara barbadiyan
and that we were exclusively based in
amawala ino ma habire barmi kegi kala ni mawala ino arala naida barma naida
had this extended jurisdiction that I reported on in my
kanun bare barma diyan.
But I wasn't dealing with Article 8, and certainly not about the reservation expressed by Burma. These questions
Burma to arhana dumba yandian or biri ne kagi gi
the academicians amongst you, honoured judges, will understand me easily.
To
those judges deprived of the very relative privilege of having been a professor. Doctrinal documents start from nothing and do not have any fixed guidelines. On the contrary, in a contentious case, you are made aware from the outset of particular or idiosyncratic conditions. They oppose their logic upon you, and I cannot see anything which seems to be a contradiction or an about turn. The context and the underlying logic are not identical. All of this is not the decisive factor in the present case. I didn't really want to raise this point, but nonetheless I was afraid that my silence might have awoken the suspicion of an embarrassment, and I preferred to dispel it.
What
would I like you to bear in mind above all from my two speeches? As follows. Whatever the objectively correct interpretation of the relationship between the interpretation whose result is to deprive of all legal effect from well, can it allow itself to ignore completely a reservation which a state has carefully attached to the convention? I'm sure that you will think deeply, and I am in no way afraid of the results that your wisdom will lead you to. These thoughts bring to an end my presentation. And could I ask you, Madam President, to be so kind as to call to the bar the agent of Myanmar for their final conclusions.
I thank Professor Koh, and I shall now give the floor to the agent of Myanmar, His Excellency Mr. Koh Man. You have the floor.
Ya ko lain putar diwa ko lain ga ke hot sai riba Burma region ase ite akhir tu ki hor yan has go yor janam zaruri
Madam President, distinguished members of the court, Counsel for Myanmar have dutifully presented their arguments to the court. Matters of law concerning jurisdiction. We have refrained from entering into the matters relevant to the merits. Counsel for the Gambia made many factual and political allegations that were not relevant to the preliminary objections.
preliminary objection amma jinne ki hata hoye hi jinne ki Gambia hata watara hoye hi le hata alkanno.
At this stage of the proceedings, Myanmar will not respond to these allegations, as now is neither the right place nor time to do so. Will not
Bormai zuru gojje Rohingya ko nenya gojje hodi hi Bormai so gojje no job no Bormai hi le ajo no ta bhabe age case asena na yalla hodi
outside the Great Hall of Justice.
endila kada insabor building
These
on mare
allegations are aimed at intimating to the members of the court and the public
nyona has gojje asuli ma kanuni ma avlara has
authorities in
sare
Myanmar should be considered perpetrators of genocide even before there has been any decisions on whether there will be a merit phase.
ar kanuni tarika le yero borma kala action level la jada asena nahi ano ta na sai yero borma jinsa ko jude di raddi di ano re
Also appear to suggest that the preliminary objections should not be considered seriously as the court has already rejected them in the previous provisional measures order.
previous bola provisional mo jadi di wala buli yero ko to to na dila accept kori wala ini han sa ko yero da kita hariam dine ga ara objection hoji no re kaya da no re
By submitting these preliminary objections as clearly foreseen by paragraph 85 of the
ar tarar
provisional
khata muta ba sajje digile pudo re bala duri sian mudbut gori faisala kori bolla bala duri gor mane dile jate
not to be prejudged on the merits
तारा तो वो तो ना आगुतुलो दियर तारा फाइसला करी ना बारी वे ये ना तो फाइसला करो मुझे जज अपना
at any merit phase. The burden of proof will be on the Gambia as applicant to prove its claims.
तारा एप्लीकेंट ओने ना तारा भी सर्टिफाइड करो ना बारी में हम लोग बुरी ना बारे
That burden now, or speak as if that burden had already been discharged. As of today, the Gambia's claim have neither been admitted to be hard, nor have they been proved, and the Gambia.
तारा हो ये नंबर आरला हम को तो मुश्किल है तो ना तारा सब तो बुरी ना बारे
Nevertheless,
अल्लाह
given that the Gambia have used this hearing as a platform to make allegations about the merits, as agent for Myanmar, I cannot just sit here in silence without responding at all.
अरे तारा तो वो तो बर्मा रह गई सब मुझे अपनी नाम आते हैं बारे में हम लोग जो
To
दिन
say that Myanmar is committed to ensuring compliance with the Genocide Convention.
जनता कन्वेंशन में भी बारे बर्मा ये हाथ को निरू वादा ना मागोरी और हम तो मानो को निरू वादा होते
Myanmar amended its penal code and the code of criminal procedure.
और कोडर देने के साथ अधिकार कानूनी आता पर आसी इनरियो मानियर सुंदर को रियर गोरे सारे मिलकर तो कानून आसी
And providing for the trial and punishment of perpetrators.
अरे जब तुम गर्दी तरह साथ अधिकार ला कानून बनाई आसी इनर कानूनी साथ ये दिया आसी
Is also implementing its obligations under the provisional measures order.
प्रोविजनल में जब दिन दिए ही इनरियो सब को रियर आरा की करी
Efforts to improve the
Implement
general
करी तो
situation
भी करी
on the ground
और ग्राउंड हालो तो मिशन पालो ऐसी
is relatively calm and peaceful.
अशांति ऐसी आता हमारे
Significant incidents of violence.
जिन्हें क्या करूँ तो पता तो कुछ नहीं
With
बोलेंगे
the reading of Myanmar's final submissions, I would like to thank you all for your careful and patient attention.
तुम्हारा शांति साथ है सुंदर को रियर को नदियाँ वाला बेगना शुक्रिया
I'm very grateful to the registrar and all the staff of the registry who have enabled the smooth and efficient conduct of this hearing, including the interpreters. It now falls to me, in accordance with Article 60, Paragraph 2 of the Rules of Court, to read the final submissions of the Republic of the Union of Myanmar. These are as follows. For the reasons given in Myanmar's written preliminary objections and in its oral arguments, at the hearing of the preliminary objections and for any other reasons the court might deem appropriate. Myanmar respectfully requests the court to adjudge and declare 1. That the court lacks jurisdiction to hear the
पूर्वोत्तरवतन आरो दराजगुरिते बर्मा हल खिलाफ पूर्वोत्तरवतन केस चलाबार इजाजत নাই
that the Gambia's application is inadmissible.
আর গেম্বিয়া তরুণ দিন দরাজগুরি হিলেন লাকিং গরদেন দিলানো
Vice Presidents, distinguished members of the court, that concludes the argument of Myanmar at this hearing of the preliminary objections. I thank you.
আর ইন্দিলা হইদি আর begin preliminary objection উনকা আমরা জবাব
Note
দিই
of the final submissions, which you have just read on behalf of Myanmar. Your statement brings to an end Myanmar's second round of oral argument. I recall that on Monday, 28 February 2022, between 3 p.m. and 4:30 p.m., the Gambia will present its second round of oral argument. The sitting is adjourned.
সোমবারে হাজিনা 4 বাজে यानी কোড় টাইম 3 বাজে গেম্বিয়া তরুণ ইতারা হইদি নর জব দিব বলি হইরে কোড় তরুণ মা বলা এতুরম মারে খতম গজে আর এই ভিডিও তো লম্বই দার গই বাইটা মারা আই অনরার দিন জানি ভত্রিম বুঝাই দিয়ে দিলা হন মু টাইম মারে ইনশাআল্লাহ বুঝাই দিম বলি আশা করি আই অনরার তো বেশা বেশি তো করে দিও অনরারে বেশা বেশি ভিডিও কল লম্বা করি ফেলাই অনরার তো দুঃখ করি বলে মাফ করে দিবা তাই হাজ করে হার গবাই এনে নমাজ মারে দোয়া করিবা এখন নমাজ টাইমে তাই ইনশাআল্লাহ বেগিনা আর বার দলইম সোমবারে আসসালামু আলাইকুম ওয়া রাহমাতুল্লাহি ওয়া বারাকাতুহু